Hi, good afternoon. You may be seated. All right, Kelly, we're back on the record. Mr. James.
Your Honor, I'll make this very brief. What I was going to say I won't say, but what I will say is I've been prosecuting cases for 14 years. I've never, in my 14 years as an assistant DA, as solicitor, and now as the elected district attorney, I have never indicted a case where, based on the evidence I had in front of me, I did not believe that an individual was guilty of the charges that I was indicting them for. I have never tried a case, on the other hand, where I had doubts or where I believed there was a possibility that I could be wrong. That is why I'm before the court. That's why I've made this motion. And it's ironic that there's an implication that somehow I would indict somebody and not believe in my case when I was indicting that person. In other words, somehow I was ethically challenged or dirty. I always thought that that would come if I tried somebody, and I had that question. It just seems absurd to me that that implication would be tossed out there, and I'm standing before the court, standing before millions of people perhaps, asking for the court to dismiss a case right before trial. And so I'm struggling to see how that lacks ethics. I'm doing what I think is right, and I'm asking the court to accept the state's motion.
All right. Thank you, Mr. James. Ms. Clegg, anything else for the record?
Other than to ask you to grant the state's motion, Your Honor? Yes, sir.
All right. All right, Lord, I'm going to take that matter under advisement, but I will definitely let you know very soon what direction that court's going to take on that motion on counts 1, 2, and 3, which was murder, malice murder, felony murder, and aggravated assault. Lawyer's approach before we go to the next motion.
Yes, sir.
Yeah.
I would follow.
Let's give it some back feed. We're back on the record. Mr. Clegg,
Yes, Your Honor.
you may proceed.
Your Honor, at this time, I would file with the clerk, if I might, in open court, a copy of a motion for continuance in this matter. I had provided a copy to Your Honor and to the state yesterday afternoon, and it is not terribly complicated. Basically, in light of the state's request to null pros counts 1, 2, and 3, which you have taken under advisement, we are now put in an interesting predicament. Mrs. Sneiderman has been indicted previously for the offense of murder, felony murder, and aggravated assault.
Well, actually, this is the third indictment.
This is the third indictment, and actually the first indictment included a charge of malice murder. It did not include felony murder nor aggravated assault. The second indictment included murder, felony murder, ag assault. The third indictment included murder, felony murder, ag assault. So all three indictments from August 2nd of last year up until today have included language accusing and alleging her with having committed the offense of murder. Okay. She has, as you are well aware, received an extraordinary degree of media attention for whatever reason, and I'm not sure if I understand exactly why. Segueing after the Hemi Newman trial, which received an extraordinary degree of media attention, and then all of a sudden she winds up getting charged. When she was arrested, her literal arrest at her home in Lake Oconee was pretty much carried live on TV. The media was present, the newspaper was present. When we had the initial bond hearing in this case, darndest thing, I was sitting home the night before watching Jeopardy and drinking a beer. And lo and behold, there was a promo for the following day, tomorrow, live, the Andrea Sneiderman bond hearing. I've been practicing criminal law since 1979. I do not recall anywhere anyone ever telecasting live a bond hearing prior to that time. Every time we have appeared in court, including the 3 different arraignments on this case, the TV cameras have been here. Every time we have had an evidentiary or motion hearing, the TV cameras have been present. Once there began to be speculation as to what was going to happen in this case, in the past week, there has been an extraordinary degree of attention paid by the media. There have been people quoted saying some pretty darn outlandish things, to be honest with you, but offering their opinion this way, that way, or any which way in regard to whether she got away with it, whether she was wrongfully accused, you name it. But the attention in the media has been unrelenting. Now, all of a sudden, and all of that has focused on the fact that here is Andrea Sneiderman, who is charged with the murder of her own husband. We are now, if we start the trial on Monday, going to trial in a case where the allegations of murder, felony murder, and aggravated assault, if the court grants a motion, are gone. What you've got to ask yourself is, given that scenario, will it be possible for this woman to get a fair trial in this court at this time, given the public following that this case has resulted in, and can she actually, on the perjury, false statement, hindering, and concealment charges, which are who's fooling who in the realm of criminal law, pretty much mundane, and ought to receive focused attention by a jury outside any sort of media spotlight, can she possibly receive a fair trial at this time? Now, I appreciate the fact that the state has stood up and said that they believe that it is appropriate under the circumstances to null pros counts 1, 2, and 3. Nonetheless, we are in a position where the state had previously presented to 3 different grand juries allegations of either murder or murder, felony murder, and aggravated assault. I just don't see how on earth she can possibly get a fair trial in the atmosphere that we now find ourselves in. Again, a perjury, false statement, hindering, and concealment trial is going to focus on, for want of a better term, some degree of minutia. It is going to not necessitate a public circus-like atmosphere. My friends in the media, for whatever reason, have found this case to be endlessly fascinating. There was actually a poll on Headline News website yesterday saying something to the effect of, did she get away with it or was she wrongfully accused? Vote now. It's astonishing. I'm dumbstruck by the degree of attention this case has gotten for whatever reason, but it has. And I will have to say this, that at the conclusion of the Newman trial, Mr. James did make certain statements concerning his opinion as to Ms. Sneiderman's guilt. That has, in my mind, contributed to the environment we find ourselves in, as well as the decision by the district attorney to go forward on 3 separate and distinct occasions with an allegation of murder against this woman. She wants a fair trial. She is entitled to a fair trial. She is entitled to have this case be resolved by the evidence that is actually presented in court, and she is not, quite frankly, she shouldn't have to have the specter of an unresolved and now null prost, if that is what the court chooses to do, murder charge hanging over her at the time she goes to trial. It ought to be a case where a jury ideally says, I wonder who on earth Andrea Sneiderman is, what's this case about, let's pay close attention and learn. I don't think that's ever going to be the case. But I think under the circumstances we find ourselves in now, we have, or I'm suggesting that if she's going to get a fair trial, we can't do it at this time. So I'm asking you to continue the case. I would suppose you will ask me, maybe you will, maybe you won't, how long should the case be continued for? I will make a suggestion. You may disagree, I will make it nonetheless. Given the media uproar in this case, I'm asking that at a minimum this case be continued for 6 months, and ideally it be continued for a year. I have never, in my entire career, either as a prosecutor or a defense attorney, made such a request at any time in the past. But given the predicament we find ourselves in right here and right now, I know of no other possible remedy to allow this woman to have a fair trial than for you to grant our motion. So I would ask you to do so, sir.
Thank you, Mr. Clinton. Mr. James, Ms. Cross, and Ms. Hill, and Mr. Pasquale.
Your Honor, the state objects to any continuance. The state is ready for trial. I don't believe that Mr. Mr. Clegg has stated, any reason to believe that 6 months from now or a year from now the situation would be any different. Describes the bond hearing that was almost a year ago, and there's no reason, and this was the media attention then. This is the media attention now. I suspect it will be the media attention in 6 years, or 6 months, or 1 year, and the state is ready for trial. We're prepared to go forward, and we'd ask the court to deny the motion. That's not to say that once we begin picking a jury, and if there becomes necessary to change the venue of the case, if it becomes necessary for a continuance at that time, the state's not representing that it would never be appropriate to continue the case for the reasons cited in the defense motion. But at this time, there's no reason to believe that the jurors who came in this morning and filled out the questionnaire wouldn't be appropriately questioned, qualified, and serve on a jury. So we'd ask you to deny the defense motion at this time.
Mr. Clegg, anything else?
The only other thing I would note is, Your Honor, given the media here today, I'm guessing, I think it's a reasonable guess that the local TV stations, the newspaper, and whomever else are going to be covering this case like nobody's business. That's the environment in which we're going to try a perjury trial. That's simply not fair.
Ms. Cross, anything else on the record?
No, sir.
Ms. Jeffries? All right, Kelly, we're back on the record. Lawyers, I have been informed, as you know, we brought to this building a number of individuals this morning who completed the questionnaires that were agreed upon by the lawyers and approved by the court. And I know I was told earlier that over 283 citizens filled out questionnaires. Mr. Clegg, you may have a point, but at this point in time, I'm not going to grant your request for a continuance. And I understand, and I can't control the media access. Unfortunately, if I deny them access, they will file an action wanting to be here. So I have allowed them to be here. We've asked those individuals to fill out questionnaires. Hopefully they've answered those questionnaires truthfully. And as of right now, we will start jury selection on Monday. And if we go through those 283 individuals and we can't find a competent jury to hear the evidence on the state versus Andrea Sneiderman, I will consider it at that point in time. But as of right now, I am not going to grant a 6-month continuance or a 1-year continuance. I try to pride myself on all serious cases. I try to specially set the murder case that I understand it may or may not be a murder case next week. But I always try to specially set those cases within a year. In this case, I believe Mrs. Sneiderman was charged back in August of last year. And based on my time schedule, we're well on the way of having this case resolved within that 1-year period of time. And I'm going to continue that at this point in time. However, when lawyers start questioning if we cannot find a fair and impartial juror, I will consider that at that point in time. But at this point in time, we're going to deny the motion for continuance. We do have another matter. I'm going to take a brief break because we're moving along because obviously some of these motions were filed this week. We're going to take a brief break to allow, let me do it this way. Lawyers approach. All right, Kelly, we're back on the record. I believe there is at least one more motion before we take a break.
Yes, Your Honor, 1 minute.
Take your time. I'm here.
Okay.
Who's going to argue this motion? Mr.
Yes, Your
Quayle?
Honor, it is one last motion, and it will be relatively brief. Yeah, and I will file it with the clerk as well. With the court's permission, I have provided a copy to the district attorney's office.
Well, Ms. Patterson and Ms. Marble will receive that. Ms. Marble's our new clerk, so she'll receive it also.
Okay. Your Honor, it is a motion for bond modification. As this court is aware, back on, I believe, I don't recall the actual day of the bond hearing, but I believe the defendant was, you did were gracious enough to grant the defendant a bond, and Mrs. Sneiderman was required as a condition of that bond to wear an ankle monitor and be subject to house arrest. So since the date of her release from custody, which I believe would have been August 21st of last year, she has been wearing the ankle monitor. She has incurred a cost of several $100s a month by virtue of having done that, and she has been under house arrest since that date. That has prohibited her from attending extracurricular functions with her children, going to school conferences, going to ballet recitals, all the sorts of things somebody would typically do who has young kids. And she has, I believe, a 7-year-old daughter and a 4-year-old son. They will be 8 and 5 later this year. She has also been prohibited from having as a condition of bond any contact with anyone who is going to be a potential witness in this case. And because we expected to call a number of these folks as witnesses, she has been cut off from a lot of her really close friends for the last year. You also set a bond in the amount of $50,000 or $500,000, $250,000 of which had to be put up in cash. What we are asking is that you modify her conditions of bond at this point, that you no longer require her to wear the ankle monitor. She has done everything she is supposed to do. I would ask you to remove also the prohibition against her communicating with her friends who may wind up being witnesses in the case. And I would ask you to, trying to think, there was one other thing I was asking, I apologize. Let her get her $250,000 and let her family get the $250,000 back. Let the property that covers the other half of the bond be unencumbered, and let her sign a $10,000 signature bond. That's what I'm asking, Judge.
All right. Mr. James? I'm sorry, Ms. Cross?
Yes, Your Honor. The motion as written, the state consents to. The motion as written asks for a reduction of bond to $10,000 and asks for the ankle monitor and the house arrest conditions to be removed, and we consent to the motion as written. However, as expanded by Mr. Clegg this afternoon, the state does object to the defendant having any contact with a potential witness, particularly a witness who will be likely in a case that begins on Monday. So I don't think that is particularly onerous. Would be typical and is a typical normal condition for any bond. She should not have any contact with potential witnesses in the case. We'd ask that to remain in place. Otherwise, the state consents to the defense motion.
Well, I may or may not do that also. Let me ask you this, Ms. Cross, or Mr. James, or Ms. Hill, Ms. Pasquale. With the, and I understand the recommendation on counts 1, 2, and 3. What's the approximate length on this trial now?
It was the same as was represented to the court before. We expect to take 5 to 7 business days to present the state's case once we get a jury seated.
From the defense?
Judge, I would expect it will shorten it somewhat, but I would expect that we will still have close to a week's worth of evidence.
I understand. And I'm saying the court possible consent. I'm gonna take it under advisement also. I'm gonna give you some direction. Let me, not for that issue, I just need to consult with my staff here, Ms. Jeffers, about a related matter, but to get some direction from her on how, if you will get some direction tonight. When I took these matters under advisement, let me just consult with Ms. Jeffries, and I'm gonna give you some direction on some of these issues so that you will have Saturday and Sunday to work those things in. We're gonna take a brief recess. I'm gonna give you some direction tonight. Brief recess. All rise. May be seated.
That's what we took a minute. Do that every time? I'll have to make that.